a child?
I think that's a very good question for the Attorney General.
Thank you, Mr. Chairman.
Any other questions? Same from our Attorney General, Chris Kobach, and welcome to Senate Fed and State, Mr. General.
Thank you, Mr. Chairman, and members of the committee. Good morning. I think you'll find this a very interesting topic, and I think it's one that everybody on the committee, Republicans and Democrats alike, will want to engage and have some thoughtful input on. I don't know if you noticed the front page of the Capitol Journal on Friday. I know that Friday's a light day usually around here, but if you got it, you might have noticed that there was an article about Federal District Judge Robinson in Kansas City imposing a penalty on 5 attorneys who submitted a brief, and in that brief, an AI app made up cases, made up quotations from those cases, and she was imposing sanctions upon the attorneys for not, going through and seeing if these cases were real. And interestingly, I heard about this 3 years ago when a New York judge did the same thing, imposed penalties on an attorney who filed an AI-generated brief. It is infusing all aspects of our lives, and even in the legal world, it's getting attorneys in trouble, and they should be in trouble for relying on AI to do this. As your state's chief law enforcement officer, it's my job, obviously, to protect Kansas consumers, protect Kansas against crime, and also to anticipate threats. And if I don't have specific legal authority from you, the legislature, to address those threats, then to ask you for the authority to address those threats. And that's what I'm doing today. As I'm sure most of you are already aware, artificial intelligence chatbots have created a host of problems, especially for children. They have encouraged teen suicide. They have generated child sexual abuse material. And there's a case of that coming from Topeka, and it's in footnote 2 of my testimony. AI has created sexualized conversations with minors, has pretended to be a licensed therapist, and of course, it, in many instances, forms sycophantic and unhealthy relationships with the user. And if that user is a minor, then the dangers are even higher that that user may start thinking of this chatbot as a person. What starts as a 13-year-old girl asking the chatbot for advice on how to dress at school, then becomes the same girl asking the chatbot for advice on how to talk to a boy she met at school, and then it becomes relying on that chatbot for advice on how to deal with her depression when things don't go well with that boy at school. It is truly, truly troubling, and I'm sure many of you have seen some of the material generated by these chatbots. So we have this bill to protect Kansans against this type of AI abuse. There are sensible exclusions for responsible business uses, as staff mentioned to you already, but it does take powerful steps to stop and discourage AI chatbots being used in the ways I've described. And as was mentioned, citizens are also empowered to bring a private right of action. I think this is really important in this bill. There are some areas where you may not necessarily want citizens empowered to have a private right of action, but here, this is one where parents who are vigilant and seeing something going on and seeing what a chatbot is encouraging their kids to do may realize that they can hire a lawyer and then take action. We have, of course, the Kansas Consumer Protection Act already, which protects Kansans against misrepresentation and fraudulent advertisement and the like, but that doesn't really cover the gamut of what the threat is from these AI chatbots. So this would, build upon that. I want to point out again that this really isn't a Republican or a Democrat issue. As you may be aware, several states have already passed similar, although not identical, AI bills. California has passed one, and it's now in effect. On the Republican side, you have Texas and Utah have already passed such legislation. There are other bills being considered right now by other legislatures. Maine, New York, Oregon are all considering bills. Tennessee is considering a bill. I encourage you to look at those bills as you work this one. And I'm going to give you some suggestions about where you might want to think about it, because this isn't an area where the Attorney General has special expertise and can say these are where all the dangers are. All of us can look at this question regardless of whether we have a law degree or not. So I want to encourage, I'll point those out in a minute. Now, some have said, well, let's wait for Congress to do something. Let's just have a national standard, and then, that'll be easier for all of these big tech companies once they have that national standard. And I'm sure they would like that. but it might be a very long wait if you're waiting for Congress. We all know how rigidly gridlocked Congress has been of late. I don't have any confidence that they are going to act soon on this. So that wait might be 1 year, 2 years, 5 years, who knows how long, and who knows how many children will be harmed by these AI chatbot technologies as they continue to get more and more human-like and more persuasive in the way they interact with the user. So I would encourage you to act and act quickly, work this bill, offer amendments as you see fit, but please get this done this session if at all possible. It's something we all have a common interest in, and again, I just don't see any partisan angle to this at all. If you look at the bill, as staff mentioned, there is on page 2 under little b, 8 different things that it is illegal for a person to knowingly train artificial intelligence to do. I would encourage you to first look at the word knowingly. In this respect, the bill is narrow. A person, a programmer at an AI generative corporation might say, well, I didn't knowingly train the chatbot to do this. I didn't want it to encourage the child to commit suicide. It could be broader there. It could be negligently. It could be a broader word. So I draw your attention to that as something to think about. Where the bill is broad is on subsection 8 under B, to simulate a human being, including an appearance, voice, or other mannerisms. That is an extremely broad part of this bill as we have presented it to you. You may want to narrow that. You may want to leave it as is. But note that there's a lot to think about here in subsection B, 1 through 8, and in B itself with the question of knowingly. But whatever you choose to do, we encourage you to do something knowing that my office will enforce it and that it will provide a tool to Kansas parents. So thank you so much for letting us bring this bill to you, and I really hope and encourage you to get something out of this committee. I'd be happy to take your questions.
And we'll go ahead and open for questions for the general. Senator Gossage.
Thank you, Mr. Chair. Thank you for the Attorney General for being here with us today. The question I have is, there are a lot of young people who are on TikTok, YouTube, whatever. I don't know if those are particularly chat bots, so they can't talk back and forth to them, but they're very influential. This does not address that. This just addresses like a Siri or something of that nature.
I don't think Siri.
Give my ignorance, but if you could help me with that.
It would be more like a Chat GPT or a Grok, an app that actually speaks to, communicates with the user as if it is a person. With respect to some of the harms that kids face on some of these other social media platforms, we have taken action, and the Office of the Attorney General has already sued TikTok and Snap, which is the Snapchat app, for their advertising of the product as safe for minors, when in fact the product is not safe for minors and we've demonstrated, has been putting sexualized material in front of minors. So we can go after them already in those types of companies for that type of harm with our Consumer Protection Act.
Thank you, Mr. Chair.
Any other questions? Senator Clifford.
Thank you, Mr. Chairman. Thanks for being here, General. For those of us who are physicians who are regulated by the State Board of Healing Arts, would we be sort of excluded from this because that's our authority, so to speak?
I don't think so. So if a physician sought to gain more, maybe there was a particular, I'm just hypothesizing here, but maybe there was a particular disability or a particular malady that your patient was suffering from, and a physician asked a chatbot to list all of the newest medicines or therapies for this. That wouldn't be violating this law. What the law does prohibit is act as if the AI is a healthcare professional. And I think that would be, the way I read this in the way we drafted it was, that's to the user. But certainly the healthcare professional can ask AI, just like a lawyer can ask AI, although I would caution a lawyer not to, can ask AI, what cases are there on this topic? That would be, a professional can certainly use it, but with great caution.
And then this gets pretty sophisticated. I mean, I've seen physicians who have their avatar interacting with patients who are calling in for information. So I don't know where that, the ending is for this.
Well, if the physician's not involved in that communication between patient and avatar, then I think that would violate subsection 5, or B5, as it's currently written. Again, if that's something you think is problematic, then you may want to either strike that or change it.
Thank you, General. Thank you, Mr. Chairman.
Other questions? Senator Fasquedo.
Thank you, Mr. Chairman. Thank you, Attorney General Kobach. So how would you make the public aware of this? Are you going to do public service announcements?
My guess is that if this becomes law, there will be plenty of media attention from reporters and others in the room. If for some reason we felt that there wasn't enough information about this or the public wasn't aware, we would consider doing PSAs. So for example, we've got a PSA running right now about the dangers of using a pill that you get from somebody or get online but not from a doctor or a physician, because there just doesn't seem to be enough public awareness. So we would have to wait and see, but we wouldn't just start spending money until we felt there was a real need.
Any other questions? Real quickly, collecting the data to prosecute seems like it might be a little bit of a trick. And this is open-ended enough, it just gives you the latitude to do that, I think.
What you probably would see, let's suppose that there's an AI device out there that looks like it's violating the law. One thing we can do is send to the company a civil investigatory demand, asking them to explain to us what's going on here. And so they would then be under an obligation to provide answers to us. So we can, it's sort of like in a pre-filing discovery, a CID is. We can, ask the company to provide information. They can refuse, and that increases the likelihood that there might be litigation. But there are ways we can get that information in advance. And I think, many of the violations here aren't necessarily ones that you're going to need to see the code to establish whether or not the violation occurred.
So, and that kind of goes to the term training. Do they provide you information with whether or not they are developing the code to do so?
And that goes back to the knowingly question. We drafted it narrowly there, but I've been wrestling with that. Maybe we should have said knowingly or negligently.
Okay. Other questions, committee? Any other? Okay, seeing none. Thank you, Mr. General. We have written only proponent testimony from Amy Campbell, Kansas Mental Health Coalition. That's in your